today we're going to be covering the prosecution's response to Kouri Richins asking for a new sentencing date. On Monday, the defense came in and said, hey, not only do we need more time, we want a different day. Can we just kick this out an additional month till June? Kathy Nestor cited several things in requesting that continuance. 1, she needed more time to prepare. 2, she had had a recent death in the family. 3, she mentioned that Ramos was going to be in trial, and because Ramos was going to be in trial, then they needed to kick it over. So there were a number of reasons that they wanted to continue the sentencing. And I was like, or is it because it's on his birthday? Like, which one? Which one is it? So the prosecution responded. So we are going to go through that objection. There is just a brief part of it that is redacted, but it is on the docket. So we're going to see what Mr. Bloodworth had to say. The state of Utah requests that the court deny the defendant's motion to continue sentencing. For 3 years, Eric Richins' family has painfully and patiently stood by as the defense has manufactured one reason after another to delay this proceeding. There is no good cause for them to suffer further delay. The time has come for the court to sentence Kouri Richins. Statement of facts, just the facts. Throughout this proceeding, the state has deferred to defense counsel on scheduling every single time without exception. It's true. On March 16th, immediately after the guilty verdict, defense counsel conferred and confirmed their availability for sentencing on May 13th, 2026. The following day, on March 17th, 2026, the defendant's aunt asked the defendant if the sentencing was scheduled on Eric Richins' birthday. I mean, we all knew it was scheduled on his birthday. The defendant answered that it was, quote, as of now, but that she, quote, told Kathy Nestor to schedule it for the end of May, and that Miss Nestor, quote, said that she would. To be fair, she had just been convicted of aggravated murder. She might not have been processing the information when they were picking the sentencing date. Her attorneys probably did not clock it. I don't think that the court clocked it. I think that the family, I'm sure, sat there and was like, yep, absolutely. But all the defense attorneys agreed. They all talked about their schedule and said, yes, we can do it that day. According to Exchange, and that's their docketing court program, Alex Ramos's trial the week of May 11th was set on March 24th, 8 days after this May 13th sentencing was set. The trial is a second place setting behind a 2021 case, and his client is out of custody. I'm going to translate that from lawyer to law nerd. They go on to talk about who the co-counsel is. Here's the thing. First of all, a second place trial is probably going to trail a couple of days or get pushed over. An out of custody defendant does not have to start trial that day the same way an in custody defendant does. If it is an older case, the older case will go first. And trying to use but counsel has a trial when that was set second is just BS. It's BS. And that's why it's being pointed out. It's like, no. This was scheduled first. If you scheduled that, you probably scheduled it knowing that it was going to trail, because you can have a trial trail behind. We don't know what day of what it is. It might be a 0 of 10 where it's going to trail for 9 more days before it even starts. But also, he is like third counsel. If he starts trial, does he have to be there at sentencing? And he picked this trial date knowing about the sentencing date. And it's an out of custody defendant. So it's not like he's within a statutory time where the court's like, you have to be here. And even if it was, you don't need all 3 counsels for sentencing. Interesting that Nestor is using Ramos's trial to try to add, weights on that side of the scale for a continuance. So if you're looking at the scale being status quo, they're trying to push the scale in favor of continuance. And they're using Ramos's trial as additional fuel or weight to do that. Rule 22 contemplates sentencing within 45 days of verdict. The 53 days currently scheduled provides sufficient time for 3 defense counsel to prepare mitigation evidence, notwithstanding Ms. Nestor's loss of a family member. A continuance would have problematic ripple effects. The deadline for post-trial motions is pinned to the date of sentencing. This is a fantastic argument. It's a fantastic argument. The deadline for post-trial motions is pinned to the date of sentencing. Kouri Richins' family members and members of the prosecution team have already scheduled time away based upon a calculation of when post-trial litigation would conclude. We picked a sentencing date. We looked at our calendars after this extensive trial and went, okay, we will be clear of these motions by this date. That means we will be clear. A month-long continuance will needlessly disrupt this scheduling. Fair. The motion is untimely in that defense counsel should have filed it by March 17th when the candid basis for the continuation request came to their attention. It goes on to say that Kouri Richins' family and the state are available all day on May 13th, should sentencing require a full day, and the week of June 15th. June 15th is indeed their wedding anniversary. So there is also an acknowledgement that if the court does decide to continue it, that there is some availability there. What would you rather, Kouri? The wedding anniversary date? The birthday? Because it's all in the files. It's hard when the defense asks for more time. The prosecution makes an excellent point. You've had well more than 45 days for sentencing. And even though there is a family tragedy, there is still a month left for sentencing. So what could possibly take another month to prepare for sentencing that they wouldn't have already prepared for trial? I don't disagree. I think the court might still give them more time. Maybe not a full month. I would love the court to say, no, I've got a full day available on the 13th. We agreed to it. You waited more than a month. It puts the prosecution and the victim's family at disadvantage. We are going to be getting into the summer. That's going to start impeding summer travel and summer plans. And the family also has rights. And the speedy sentencing is fair. I'm curious to see what the defense says. And the defense is, my guess would be something along the lines of, but Your Honor, we need more time. We need time to adequately prepare. This is a significant sentencing. And the court might actually just hold an informal conference with counsel and be like, what dates are you guys available? We're not going all the way out till June. Let's figure out what dates you're available. Because it's a lot of people to move. Or the court might say, which I would hope, but I don't know if that's realistic. The court might say, no, you agreed on this. You had enough time and you waited a month after your client said, let's continue this before you filed it with the court. Why wait? Why wait till a month out? It would be easier for everyone to reschedule. Well, maybe because there isn't good cause when there's still 2 months away. Because what would the court say? You still have time. Like, just get it done. You've got time. We're not moving the deadline. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.